So last Friday on the 20th of March, the government issued the Renters' Rights Act Information Sheet 2026. And ultimately, this is a 4-page sheet which details what the Renters' Rights Act is, what it includes, and it ultimately explains it to tenants so that they understand their rights. Now, on the government website, it does say that all landlords, letting agents should issue this to their respective tenants before the 31st of May 2026. If you do not do so, then you could be liable up to a £7,000 fine. I know, crazy. So it's very, very important that you do issue this to all your tenants. And it does say on the government website that you can either do this via an email or via post. Personally, I'm going to just do both. I'm going to send an email to my tenants, and then also I'm going to send it via post as well, have a proof of posting there as well, so that I'm able, in any event, prove that I did post the relevant information. So what is actually in the Renters' Rights Act information sheet? So first of all, it details Section 21. So I've spoken about this multiple times on this channel, and this is the no-fault eviction. So this has been abolished from May the 1st, 2026. Landlords cannot issue a Section 21 on a tenant. Now, it does specify in the information sheet that if a landlord has actually served Section 21 before the 1st of May, then a lot of the things that are being outlined in the sheet may not relate to the tenant because, of course, they're being served with a no-fault eviction prior to the deadline date. It then also details how fixed terms are changing. So if any tenant is on a 6-month contract, a 12-month contract, then from the 1st of May 2026, this will then become periodic. So it will just move on to a roll-on monthly contract. It also details that the name will change ultimately from an assured short-hold tenancy. Currently, that's what the standard agreements are between landlords and tenants, or letting agents acting on behalf of the landlords and tenants. And this will be changed to assured periodic tenancies. Now, it also specifies rent increases as well. So any rent reviews, rent clauses that were set in the assured short-hold tenancy agreement ultimately is going to be scrapped from the 1st of May. So after the 1st of May, landlords can only actually increase the rent once every single year. So, I mean, I've never really increased rent more than once a year anyway, so this doesn't affect me at all. But it's now law. So you can only increase rent once a year, and you have to do this via Section 13 of the Housing Act 1988. And you must fill out a form called Form 4A and give tenants at least 2 months notice before that rent increase actually comes into play. Now, it cannot be above market rent. And if the tenant believes that the rent that you've actually proposed is above market rent, they can actually challenge this at a tribunal. And even if you were to succeed, then the rent increase would only actually come into effect from when the tribunal case landed in your favour. So it's always important to ensure that any rent increase that you're doing is fair and in line with the market. Now, this ties in a little bit into my first point with regards to Section 21, but it also does detail in the Renters' Rights Act information sheet how a landlord can actually take back their property. So it details the specific reasons why a landlord may be able to take back a property from the tenant. Now, that includes rent arrears or not paying your rent on time. It includes antisocial behaviour, you or members that are living in the property not taking care of the property, and this is evidenced by the landlord. If after the first 12 months of you living in the property, the landlord now wants to sell the property, or they either want to move into the property or their family member wants to move in, then they can actually take back the property from you. Again, from May the 1st, they can't just take back the property for no reason. There needs to be a reason, and this is outlined. And this will fall under Section 8, and a landlord can use one or more of the possession reasons there. And now as a tenant, if you want to end the tenancy, then you have to give a 2 months notice, and you have to ensure that the last date is either on the due date of the rent or the day before. And ultimately, this is just so that you're able to pay the last month's rent, and you're either not going to be owed any rent from the landlord, or you're not going to owe rent to the landlord. So it just means that there's a clean break and you're able to cleanly exit the tenancy. There's also some bits around pet requests. You are eligible to request a pet, and a landlord can't unreasonably refuse your request. So they need to have a legitimate reason. So it might be that actually on their lease terms, if they own a flat, that it does state that animals cannot live within the flats. So unless there's a reason like that, then a landlord can't just refuse that request. So hopefully this helped you understand a little bit about what the Renters' Rights Act Information Sheet 2026 actually includes, and to ensure, most importantly, that you serve it to your tenants and you do it in a timely fashion as well. And I'd recommend doing it via email and then also via post as well, where you actually have the proof that you've actually sent it, and this just ensures that you're covered, so the government don't come knocking on your door expecting to pay a hefty fine. So if you enjoyed this video, do give it a like, and you found value from this video or any other video on the channel, and do subscribe as well. And until next time, happy investing.